Hey, Tony DeWitt here, Missouri Appellate Attorney. I'm retired, and this is not legal advice. Everything I say is simply commenting on the law, and this will be what we're commenting on today. A couple of things before we get started. A little programming note. I am going to take Wednesday, Thursday, Friday off, and I will be back next Monday after the holidays. And it's important to take one holiday at a time, so I'm going to spend my time being thankful. And I wanted you all to know one of the things I will be most thankful for, frankly, is you all. So there you have it. That's the first of the programming notes. The second is if you hear a little background noise that sounds a little bit like somebody changing a tire or something, it's actually my bread maker, which is in the process of making some cinnamon rolls. My eldest grandson will turn 15 tomorrow, same birthday as my grandmother, in fact. And so I'm making him some cinnamon rolls for breakfast tomorrow. So there's my kind thing that I did today because he loves cinnamon rolls. But then again, who doesn't? Just a note before I start discussing these cases all involved either dismissals or settlements. And as a result, none of the allegations were proven. And as a result, you can't say that any of the things that were said in the pleadings are facts. They were what people believed the facts would be. But that's the reason why I am not naming these companies, because they did not have the full benefit of due process in these cases, or I guess one of them did in terms of getting it dismissed, but it had nothing to do with the substance of the allegations. So just keep that in mind. I'm not deliberately trying to be vague about this, but some circumspection is necessary just to prevent people from being up in arms. On to the topic at hand. In January, the administration will change over from Democrat to Republican, from President Biden to President Trump. Every time there is a change in administration and a change in the leadership of the Department of Justice, I hope for a meaningful change in the culture of that department. Now, I want to be clear, I'm not talking about politics here because the problem I'm going to address here goes back a long way. I've had this same criticism under the Department of Justice under George H.W. Bush, Bill Clinton, George W. Bush, Barack Obama, Donald Trump, and Joe Biden. So this criticism doesn't relate to who holds the Oval Office, but rather to the culture of the Department of Justice, which never seems to change no matter who the Attorney General is. When people talk about the deep state, I think that's what they mean. It's the same old people doing the same lower level jobs, and they get to feel like they are running the train. And they're not supposed to be, but in some respects, I guess they really are. But the attorney, like I said, the culture doesn't change, and in my view, it needs to. I want to talk about a specific statute here today. It's 31 United States Code, Section 3729. If you get on the Google and look that up, what you'll find is it's called the False Claims Act. And under that statute, the Attorney General is responsible for the prosecution of cases filed by private relators against those who file false claims against the United States. So if your doctor spent 2 minutes with you and billed Medicare for an extended visit, well, that would be a false claim, among other things. Probably also be very bad medicine. The statute came into being, and it was called the Lincoln Law because it was basically designed by Abraham Lincoln. During the Civil War, profiteers made thousands of dollars selling uniforms to the Army, and those Union Army uniforms were often defective. They were made out of what's called shod, which is the wool that's combed off of wool that's used to make fabric. Well, it looks a lot like regular wool, but it has this annoying tendency to fall apart when it rains. So if you can imagine somebody from up north coming down in a wool uniform hitting some of the rain in the south, which is very seldom is it warm rain, those poor guys had a lot to contend with. Not only were rebels shooting at them, but their uniforms were falling apart on them. In addition to that, the Union bought muskets that were not capable of hitting the broadside of a barn. The Union quartermaster would often requisition things from people out in the public. He'd go to the guy and requisition 10 horses and the seller would add a zero to the requisition and collect for a hundred horses. There were hundreds of people cashing in on the government's need to fight the Civil War. Well, not much has changed, frankly. Today, everyone is aware of the $1,000 toilet seat and the $900 hammer, as well as the many things sold to the government that just don't work out. Maybe you remember this one. On April 2nd, 2012, the General Services Administration Inspector General released a report that many at the time thought might change the way the agency was operated and run. On that day, the GSA's Inspector General, the watchdog, released its Management Deficiency Report, one of the most explosive looks at a federal agency in a long time. The IG had unearthed details of really bad spending, including a conference that involved luxury hotels in Las Vegas, hot tubs, and, get this, mind readers. If you don't remember that from 2012, I can tell you it was a debacle, and the GSA looked really bad over it. But if you don't know anything about it today, that's because that has been memory holed by the government. In the aftermath of that headline grabbing story, which sort of shook the GSA all the way down to its, lower levels, heads rolled and laws were changed. The administrator, her name was Martha Johnson, she was fired, and the agency cleaned house at its public building service. They were the people who put on the conference. Just a month after the report came out, the Obama administration released a memo demanding all agencies reduce spending on conferences. Now, the GSA had spent over $800,000 on its little Vegas affair with the mind readers. You would think that the mind readers could have told them, hey, that's a bad deal, don't do that. But apparently, it's like the lady who was claiming that in the accident she lost her ability to be precognitive. You know, she'd lost her ability to see the future because of the car accident that she was involved in. If she'd really had any kind of ability to see the future, she wouldn't have been involved in the car accident. But I digress. The problem was that GSA just routinely spent a lot more money than it needed to spend. And the problem was that the boondoggle made national news and the agency head lost her job. Others at the GSA took note. The way to avoid getting embroiled in a scandal was to keep anyone else from looking at it. That was the lesson at the GSA. Note, the lesson wasn't do things that are scandalous. It was, in fact, don't get caught. Now, you're probably wondering what this has to do with my hopes for a change in the DOJ, because after all, we're talking about the GSA, not the DOJ. Well, let me see if I can explain this. When the Department of Justice gets a False Claims Act case, it's charged with managing the investigation of it. The government gets 60 days to investigate and make a determination as to whether or not it wishes to intervene. Unfortunately, it never gets the investigation done in 60 days. It always takes, at the very minimum, 6 months, and I've had these go on for, hold on now, 9 years. But most false claims acts are criminal, or they're at least somewhat criminal in nature. Somebody's lying, somebody's cheating, somebody's doing something that they shouldn't be doing, and it's a crime. But unfortunately, it's not the kind of case that gets a federal agent promoted, no matter how much money is involved. If all the government does is get back several $1,000,000, that's not even worth an attaboy to most of these guys. So the DOJ's own investigative agency, that's the FBI, they aren't interested in chasing down nickels and dimes. They want headline-making cases involving criminals, not white-collar crime like GSA fraud. Although they can be dragged kicking and screaming from underneath their desk into an investigation, for example, like the Bernie Madoff affair, for the most part, they tend to stay away or shy away from False Claims Act cases. Now, that's not to say that when I've done these cases, I haven't had good FBI agents, because I have. But I've also had very bad FBI agents, not in the corruption sense, but just in the unwillingness to exert effort sense. So, since the DOJ doesn't want to use the FBI, on something like this, then whenever a False Claims Act case is filed involving an agency, for example, like the Health and Human Services, well, the Health and Human Services OIG provides the investigators. And the HHS OIG investigators have the same ability to arrest criminals, carry guns, and do all the other stuff that the FBI does. If it involves the Defense Department, the Defense Criminal Investigative Service, kind of like the Postal Service, it's one of those investigative services with the best conviction record. It investigates fraud in the Department of Defense. And the GSA OIG, the same office that oversaw the Las Vegas GSA scandal, it investigates claims of fraud affecting the Government Services Administration. Now, the DOJ refers to these agencies, like the GSA, as the client agency. In other words, the DOJ thinks of the GSA as its client because all lawyers have a duty of loyalty to the client. It puts the needs of the client ahead of the needs of the taxpayer who's paying the bill. With all due respect to the DOJ internal policy regarding the agency as client, the real party in interest in a False Claims Act case is the American taxpayer. It's her interest that should be protected, not that of the bureaucrats in the District of Columbia. But even worse than the client agency problem is the fact that many of the lawyers in the DOJ Civil Fraud Division are salaried employees whose compensation doesn't change whether they're successful or unsuccessful in the cases they are assigned and manage. If they get 50 cases a year and they decline to intervene in 45 of them, keeping only 5 maybe of the bigger cases, no one at the DOJ says a word. So an attorney with the DOJ in this division only works as hard as he or she really wants to. Now, I want to point out that there are many of these lawyers who are committed, dedicated attorneys who fight hard for the government. They take on big companies with battalions of lawyers, and they prevail because they work hard. These guys have been a pleasure to work with over the years, but there are some, certainly not a majority, but some that just want to put in their hours, collect a check, and lay claim at parties to being a super important lawyer working for the Department of Justice. I have unfortunately run up against a number of these in cases involving pretty significant fraud, but I want to highlight a case involving the Government Services Administration. Now, a private power company, who I'm not going to identify, controlled by the State Public Service Commission, came to a certain GSA local administrator and told them that they had a great idea. Instead of heating a certain federal building with steam, which had been the rule for decades, they would sell the GSA an electric boiler, supposedly that was high efficiency, that would allow them to make their own steam so they wouldn't have to buy it, and because they're using the boiler and it didn't have to travel through pipes, they could use less of it. And then they could heat the building with that steam. To sweeten the deal for the GSA, the power company promised to give it a sweetheart deal on the electric rate. Now, there was one guy who worked there who knew this couldn't work and wouldn't work. He went to the people in charge and explained that the Public Service Commission that controlled the utility would never let the power company give the federal government the electric rate because the PSC had announced 6 months earlier that the rate was being phased out. While people who had that rate would be able to keep it, those who did not have it when it was phased out could no longer get it. Since the boiler project would take longer than a year to complete, he knew that the rate would never come to pass. So, aware of this pushback, the power company went on a charm offensive, or, if you prefer, a fraud offensive. At least that was the allegation in the complaint. The GSA mucky mucks who were invited to golf tournaments with the company had their green fees paid for them. And, depending on how they shook out in the competition, they were awarded prizes like flat screen TVs. Now, a lot of the higher ranking employees in the chain of approval of the deal were the people who went to those golf tournaments. Then there were the trips to the local NFL stadium. In the company's skybox, alcohol and appetizers like peel and eat shrimp flowed freely. In spite of pushback from lower level employees, the deal got approved. Then, right on cue, the Public Service Commission announced it would not let the company give the government that insanely low rate they'd offered as the chief inducement to the deal, and suddenly, instead of paying X dollars for a pound of steam, they were paying 3X a pound for a pound of steam. And that was a pound of steam that was produced by their own boilers. In other words, it was 3 times as expensive to get the steam done by the boilers as it was to buy it from the supplier who provided the steam previously. If that wasn't bad enough, the boilers were so temperamental that a standby hookup to the old steam service was required for when the boilers were down for one reason or another. Then the GSA employee who had been against the boondoggle from the beginning filed a federal False Claims Act lawsuit, and the DOJ asked the GSA OIG to investigate this debacle, approximately 7 months after the news broke about the GSA conference in Las Vegas. Here is a photograph of that GSA OIG agent investigating the allegations in the complaint, which included all the inappropriate relationships and freebie giveaways, which, by the way, no federal employee is ever allowed to take some kind of gratuity. The government always has the right to take over a False Claims Act case and prosecute it on its own. So even if the relator comes and says, look, we're willing to take this case on, the federal government can say, hey, you guys take a back seat, we're driving this train. And in fact, that's what most lawyers would like to have happen. They'd love to have the DOJ, which is the equivalent of having a 500-pound gorilla on your team. They would love to have that 500-pound gorilla go after the bad guys. And it should have done that in this case. But the client agency, the GSA, told them not to intervene. They wouldn't support intervention. Almost like the agency didn't want to have to explain to Congress how it spent $6 million on boilers that never worked to pay 3 times more for heat for a building. So, as you might guess, in that situation, the DOJ declined. But the relator who filed the case pressed on. The statute gives the relator that right. The relator can take the case forward, and if the relator recovers money, he gets a bigger reward than he would if the government took over the case. So right out of the gate, the defendant alleged that the events at issue had been publicly disclosed, and they moved to dismiss. The court denied the motion, and discovery ensued. The attorneys spent thousands of dollars gathering evidence, and the more they gathered, the worse the case got for the fraudsters. Then, mysteriously, the week before the case was set for a jury trial, the company filed a second motion to dismiss for this public disclosure. Under the law, the Department of Justice could have objected and allowed the case to go to trial, even though they had not intervened. But they refused to exercise that option, even though they had seen all of the evidence gathered by the relator during the discovery phase. Even though the government had declined, the relator felt good about the facts and the law, but the judge granted the motion to dismiss, and the Eighth Circuit Court of Appeal, pretty much like the picture of the GSA OIG agent, well, they affirmed the district court, burying a loss much greater than the mere $6 million paid for the boilers. But you see, the GSA actually made out like bandits because there was no bad publicity for the GSA and none for the company. No newspaper would get involved with the story. Everything was swept neatly under the rug, and the taxpayers were fleeced. And the oversight of the case from the DOJ was uninterested because it was only, quote, a $6 million case. Now, I don't know about you, but if I saw $6 million sitting out there on the street and it said free money, take it away, I'm pretty sure I'd pick it up. I'd pick up the $6 million, not the DOJ. If the GSA OIG had been doing his job, he would have filed charges against the people who approved the deal. He would have supported the case. He would have insisted that the government intervene and insist that they took the case forward. But the word had allegedly come down from on high at GSA that there would be no more revelations of fraud or abuse at the GSA come hell or high water. Now, I want to make sure to be fair about this. The problem here wasn't that the DOJ attorneys were lazy. It wasn't that the DOJ attorneys acted in a way that was different than the policy of the DOJ in general. It was in that particular case, they simply didn't have the ability to go above and beyond and take this up the chain of command to find out if it's really a good idea to just not take on cases that they don't have to put forth any effort in. If they had objected to the dismissal, as was their right under the law, then it would have fallen to the attorneys who were trying the case to bring in a verdict. And if they didn't, then the DOJ attorneys could say, wow, whew, boy, we dodged a big one there. And on the other hand, if they were successful and brought in money, they can say, hey, look what we did. We got those boys to home plate. We got them up to bat and they hit a home run, and now we're going to share in the proceeds, right? That would have been what they had done. But unfortunately, even though the statute passed in 2010 and it gave them a right to object, by 2015, when this case was going to be tried, the Department of Justice hadn't formulated a policy over when they were going to object and when they were not going to object, so they just didn't object at all to anything, anywhere. In other words, thanks for the option, Congress. Not really interested in doing that. And that's not the line attorneys who are making the decision on these cases. That's the people in the mid-level management who simply couldn't be bothered to formulate a policy. So here's what I wish for. This is sort of my Christmas wish. I want somebody at the DOJ to become a taxpayer advocate. And every case that is declined by the Department of Justice should have to pass by that taxpayer advocate and justify why it is in the taxpayer's best interest not to go collect free money. I want a DOJ attorney hired solely and specifically to push back against cases that show promise, but that are a drop in the bucket. It's important to recognize that in New York City, during Mayor Giuliani's time, he went after turnstile jumpers and he instituted proactive policing, and crime went down because it turns out that when you prosecute the petty criminals and show that you're insisting upon compliance with the law, with people who provide services to the government, for example, turning square corners, well, then crime goes down, fraud goes down, all kinds of miscreants stop crawling out from the woodwork to cause problems. Criminals knew they were not going to get away with stealing. You handle the drop in the buck cases, you send a message that there's a new sheriff in town and she isn't playing around. Enforcement sends a message. Pamela Bondi, the new Trump AG pick, has a chance here to make a big difference in FCA enforcement. Hire people who can advocate for the people and not for the cloistered bureaucrats hiding in oak-paneled offices in D.C. So, boy, that was a long one. Sorry about that, but it's an important thing, and I hope you feel as passionately about it as I do. If you have any questions, drop them in the comments down below. Like, share, subscribe. If you have the opportunity today, do something nice for somebody. Go out of your way, do something nice, and maybe just open a door. Maybe just tell somebody they're having a great day. Do something nice, then come on back down here tomorrow. Join me at the beach, and we'll talk about something else. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point, and although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. And here are some videos that YouTube thinks you may enjoy.